Our next session is going to look at the best interest principle in relation to childcare proceedings. So it gives us a chance to go a bit deeper in relation to those cases and in relation to the care system as well. And what I want to do is to hand over to the chair at this appropriate time. I didn't get it quite right last time round, to Emer Fisher. And many of you will know Emer Fisher was previously, the last time I saw her, she was the Assistant Secretary General with responsibility for this area in the Department of Children, but she went into retirement. And she's now stepped in as Interim Director for the Irish Human Rights Commission. And she tells me when she got the phone call for this role, she was doing what I would fantasize about my retirement. She was up a mountain in the Alps when she got the phone call to take on this role. So I'm really delighted to have a chance to pass over to Emer to lead the next part of our discussion.
Thanks very much, Tanya. This afternoon. Good afternoon, everybody. My name is Emer Fisher, and I'm the acting Director at the Irish Human Rights and Equality Commission, IREC. So I have the honour of standing in today for Sinead Gibney, who is our Chief Commissioner, who unfortunately can't be with us. And you may understand that coming from the IREC House, we know that the views of children and young people are vital to the development of child-centred policies and protections. I believe that Ireland is recognised as a leader in the area of child protection generally, ensuring that the voices and experiences of children and young people are central to policy development, reflects a core value in our society, where children can flourish and see a brighter future. The commitment to hearing the voice of the child extends to all aspects of the child's interaction with the state. And that's why today's plenary session, focusing on how those voices are heard in the context of childcare proceedings, is so important. My thanks to my former colleagues in the Department of Children, Equality, Disability, Integration and Youth, as well as the Council of Europe, and my former colleagues in the Department of Justice, for all your work in bringing this event together. So this session will highlight Irish best practice in the area and will allow you, the audience, to hear from speakers who represent the component parts making up the multidisciplinary approach favoured by Ireland. And input will be provided by the state, judiciary and civil society. So we have 5 presentations of approximately 5 minutes each, and then we'll have an opportunity for questions, and we'd really welcome some questions from the audience, and we'll have time for that. So first of all, we have Marissa Corbett, who's going to come in. Dr. Marissa Corbett is the CEO of the Child Law Project. Come on, Maria. And she has taken over from Dr. Carol Coulter, and who has introduced the whole raison d'etre of the Child Law Project. It's a superb lens that we have in Ireland in relation to attending and reporting on childcare court proceedings. So with no further ado, to Dr. Marissa Corbett. Thank you.
Super. Thanks so much. It's wonderful to be here. So after that kind of fascinating inputs this morning, I thought I'd try and build on it a little bit to try and give you a sense as to how we see it in the Child Law Project, which Carol described earlier, where we're sitting in court and listening to the proceedings unfold, watching them proceed. So I suppose the first thing, as Regina has set out, is that children in childcare proceedings have a right to protection. They've got a right to have their views heard. They also have a right to respect for family life. So under Irish law, under our constitution, and reflecting international human rights law, the courts and all of the decisions must be made with the best interest of the child as a paramount consideration, but also that decisions must be proportionate. So I'm going to talk a little bit about that. Obviously, when a judge has a case before them, the main thing that they're looking at is the threshold met to make a decision to bring the child into care. So that is whether the parents have been considered to have failed their child and there is evidence of harm to the child or risk of harm to a child. So just bear that in mind as we talk through that this is about child protection, it's about that decision. But that decision has to be made in a broader context of what's in the best interest of the child. So the concept of proportionality, and this is where it gets a bit tricky for the judges, is that you shouldn't take a child into care unless it's a measure of last resort. So when we see cases coming before the courts where, as Carol has described and other speakers have, the key issue is parental mental illness, it is homelessness, it is addiction. very common cognitive impairment disability. So clearly we've heard that you're not meant to take a child into care on the grounds of poverty, linked to homelessness, on the grounds of disability. But if the judge is faced with a case where there's significant harm presenting, they have to make a decision to take the child into care. So the issue of proportionality is the state needs to be working throughout the continuum of engagement with the family, not just at the point of court, to ensure that you have services in place, family support services, to prevent the need for things to reach the point whereby they're in front of the judge with a crisis and the child needs a care order to ensure their safety. You also, when you get to the point of making a decision to take a child into care, in terms of being proportionate, you need to look at what are the options here. So in Ireland, we do have, very fortunately, an option to foster a child and also for relatives to foster a child, as we heard earlier. There's also lots of other options. It could be that there is more family support and the child remains at home under supervision. We would like to see that come into play more. We don't hear enough of that. Other options, other alternatives that could be explored before the child is removed from their family, their community, and moved into a care situation. Obviously, once a child is brought into care, the proportionality still continues. There is a onus, a positive duty on the state to work actively to support the family to reunify the child and the parents. All of this is couched in if it is safe. If it is appropriate. But there is a duty, and again, we don't see that enough in the courts. We see the decision is made, the child needs to come into care, it's very clear the threshold is met, the child comes into care, but what happens next? What happens after that? Can we reunify the child? Then I'm just going to move on a little bit to the best interest. I loved Regina saying it's easy to say. It is so easy to say. We hear it all the time. Everybody in court says, the social worker says, best interest of the child is in care. They shouldn't see their mother who has addiction issues. Best interest of the child not to have contact with the mother, not to have access visits. The mother's legal representative gets up and says, best interest of the child, right to respect for family life, the child needs the mother and the child need to meet. The independent guardian, gets up and says best interest of the child. So you have a lot of the same message coming to the judge, who has to make the determination as to where is the best interest of the child. Everybody is claiming it, so who owns it? And I think it is just so important that the Council of Europe have set out to develop guidance, because a phrase is a phrase. It means nothing unless there is something behind it. The Minister, Roderick O'Gorman, who was here this morning, he didn't say something which I wish we'd given him more time, because it's a very good news day for Ireland, and it's great to be able to say this, that we have introduced in our law, in our statute law, an onus that the court must take the best interest of the child as paramount, and then also 7 criteria that must be taken into consideration when making that determination. That is very important, but it is only a start, because who's going to go through those 7 steps? Who's going to give the judge that assessment? In the Irish system, there's a lot of expert input into papers submitted into the courts. In other jurisdictions, I know the judge himself or herself will do that piece of work, but different jurisdictions need to figure that out. Who's doing that analysis? Very importantly, of those 7 criteria is the views of the child. We've heard that continually this morning. That must be part of determining what is in the best interest of the child. Other things that I would just flag is it has to be time sensitive. What's best for the child, what their views are, shifts hugely as time goes on for children. So it has to have, there is a timeliness there. And also just generally, delay means a good decision made at one point is no longer the right decision if there's been a delay, because often cases are dragging through the courts for a long period of time. We've also got an element of culture. So we talked here earlier about they thought they were doing the right thing. And there is a huge amount of movement of people across Europe, in Ireland. When we see children the parents coming before the courts, there is a significant majority, a significant proportion, a quarter of those parents are from ethnic minorities. So a lot of them are migrants. There's a lot of movement of people. We need to be thinking about that. Obviously, the European Union has the Brussels II bis regulation, which is really important. What else is happening? How is the Council of Europe going to deal with this movement of children across Europe? I'd also like to note that when we're thinking through all of these things, we have to recognise that the courts are overworked. I know we've got the President of the District Court here. They are overworked. We're seeing the cases, the lists coming before them. And they need more resources. I know we're constantly saying it. They're doing very good work under difficult circumstances, so there has to be resources to ensure they have the capacity. I'm over time now. I couldn't see that. I'm sorry. I just one final thing, just on terms of views, and we might come back to this. Is we've talked about the views of the child. We've talked about the importance of children meeting directly or indirectly with judges. But I also think we need to be thinking about, what about children participating in proceedings? They don't in Ireland. What about having children having their own agency, their own autonomy to make decisions? Why shouldn't a 16-year-old be able to say, I do not want to see that individual. I don't define them as family. I see this person now, my foster family or somebody else, important to me. Give them more agency and empowerment. And I'll leave it there because I'm conscious of time, and I couldn't see. I'm so short that I couldn't see the time, so I'm so sorry. I've my notes here blocking it, so sorry about that.
Not at all, Maria. I think everything you said was really, really important, and important that we gave you the time, even how brief it was, to hear what you've got to say. So now we have Ger Brophy, who's the Chief Social Worker with Tusla, and Tusla is our child and family agency. It's a very important organisation in Irish society which plays a key role in relation to representing the child protection and bringing the cases to court on behalf of the state to ensure that children are cared for properly. So I'll hand it over to you, Ger.
Thanks, Emer. It is with some trepidation, I have to say, that I come up here today as a social worker, and lots of social workers haven't been mentioned before. It is in a real spirit of humility, I have to say. And one of the things that I think are really important as social workers is that humility and that spirit of inquiry that we need to bring with us. As a social worker, I've been committed to hearing children, supporting children to being heard, creating an audience. And I'm going to say a little bit about that today in the 5 minutes. I'm going to try and stick to the 5 minutes. But more than anything, I think how we do it is what matters if we build on relationships. It's all about the relationship and about coming to that with humility. So I'm going to say a little bit about the agency that I work with. So I'm from an agency called Tusla, a word which is unpopular with some people in Ireland for esoteric reasons, I think. But it's coming from a place where, when the agency was being set up, we sat down with a group of children and asked them what would be important for them for an agency to be set up in the country. It was only set up in 2014. And what came back was, we wanted to be bright, colourful, hopeful, and we wanted to have an identity. We don't want to be the CFA. We don't want to be the IMF. We don't want to be letters. We want to give it something of its own. And so what they did was, for right or wrong, they came up with two Irish words: Tusla, New Day, T-U-S-L-A. And that reminds us that every generation of children have a new opportunity and new challenges, and we have to meet them. That's what we are doing here today. That's the agency I represent. And Tusla, as an agency, is involved in child protection, children in care, adoption, aftercare, early welfare for families as well. We're not alone in that area. Preschool registration, and a variety of other areas. What we've tried to do, and again, if I could do what Lem was doing with my slides, I'd get this very, what was the word he used, Alan? Slickly, wasn't it, John? Moving on to the next one. Do I have to point it at something? Yes. We tried to reflect that in our buildings. So this is one of the new buildings we have in Tusla. We've tried to regenerate a lot of the buildings we have, because we ended up in old, decrepit places, inviting children and families into places where there was no light. I remember in one place I worked, it was literally a converted shed. So we've tried to do that over the last 4 or 5 years, to make places bright, to make them inviting, to make them places that children want to be. That's one part of it, and we try and do the same inside those buildings. But you don't build participation by just building a building. You have to have a strategy. And we have a strategy that's meant to be 2019 to 2023. And the aim in that strategy is that every time a decision is taken that directly affects a child or a young person, individually or collectively, that their views are taken into consideration. So that's what we've set out to do. And we've based that on the Lundy model, which we've adopted in the agency, where we try and create space for children to give their view. We give them the environment, the support to have their voice. So how do you do that? You create conferences, you create groups, you have participation days, you bring them together. We create an audience so they can be heard. So, like today with EPIC, and again we're delighted working with Marissa, and you'll hear from Marissa in a moment, we're delighted to be supporting EPIC and to be working alongside them in that advocacy role. And then, once you have the audience, you try and give it influence. So again and again, we have to hear what the children are saying. It has to make a difference in what we're doing. So I suppose, moving on from that strategy, how do we do this in practice? The important thing is relationship between the child and the social worker. One of the things we hear from children again and again in our feedback forms, and we do encourage that feedback from children, is that they find it really difficult retelling that story over and over again. Why do you have to do that? Lauren mentioned 1 foster home, 12 social workers. We can't get people to be social workers at the moment. There aren't enough people coming forward to be social care workers or social workers. Training is one of the words that I've heard mentioned again and again today. The training is difficult, the training is long, but we need it. We need to have people in this really delicate environment, this very volatile and complex environment, who are well trained, but we can't get people to do it. Therefore, we have a constant turnover. We need to mind them as well. I say to people, I'm a social worker, and the response you get back is, oh God, I wouldn't do that. How do you do that? It has been a really enjoyable pathway for me, for my life. I've got so much back from working with children. But it is difficult. Because we're getting the same trauma, we're hearing the same trauma, going through the same trauma. I've buried children that I've worked with, I've buried their parents. I've worked with children, seen them through college, I've seen them go into work. I've seen children who struggled and recovered. That's all taking a cost as well. So I'm really conscious that 3 young people who are here today, they're a really hard audience as well, and they tell me, they're not too long telling me where we're going right and where we're going wrong. So in that, we have to have an emphasis on building strengths and identifying needs, and I'm hoping that clock was starting at the wrong time. In terms of court, in all our initial assessments, the child has to be seen. The child's voice has to be heard. And that's something we've put huge emphasis on for every individual child that we're involved in. The child must be seen. All our forms and templates reflect that. So that piece has to be filled in on those forms, and all our ICT reflects that as well. Over COVID, children had difficulty attending reviews. In some ways, that was a real opportunity. The pressure was off to attend, and young people could use social media, they could use Teams, they could use a variety of different means to attend and give their view, or could give something in writing, and it was accepted because nobody could attend. So we've tried to build on that post-COVID as well, and to increase that involvement of children. Letters, drawings, messages, all of that, trying to build that influence of children. We have adopted as well in the last number of years the signs of safety as a model in child protection and welfare. And again, we use the 3 houses, we use a variety of tools. It could be 3 butterflies, 3 makeup bottles, but something that the child will reflect with to express their worries, their dreams, and their good things. And again, we try to adopt this as a standard. But if you don't have the relationship with the child, if you're not listening to the child, that's really meaningless. So you have to have that relationship to start with. I have another slide there about our court report templates. But actually, just on this one, I want to pick up on words and pictures as well, because this again is really important. Explaining to a child how things happen, having a record of that. We do, with the signs of safety, we do these stick pictures So you have a stick individual, a man, a woman, a child, and you explain, you go through a series of these very simple pictures with explanation beneath it about what has happened for the child. Why is this child in the court process? Why is a care order being taken? And that's not just useful for children, but that's really useful for adults. It's really useful to break that down to explain why is this happening, and more importantly, how can we now create safety? How can we go on to the next step? How can we make it safe for the child to be there? We hear back in inspection reports about children as well. You know, this is one here. I feel comfortable with my social worker when I'm upset. She checks out everything is okay. But then we get that negative feedback about that constantly changing social worker as well. The last thing I want to do is just bring your attention to a website that has been developed by children for children. It's www.changingfutures.ie. You'll have a phone, look it up. It's really good. And on this website, this is a participation group within Tusla over the last number of years. Children can go online, see what services Tusla offer in a child-friendly way, and then make contact with the duty intake service in their local area if they want to seek help or they have something that they want to say. So it gives a direct link into that in each of the 17 areas. And finally, just want to thank you for your attention today. Alliances are really important. And in this alliance, I think we need to put the children's voice first. And we need to be led by that. And I'm delighted you were here today to do that. And thank you very much.
Thanks, Ger. Now we'll have Marissa Ryan, who's the CEO of EPIC, that wonderful organisation which brings the voice of many children and young adults to policymakers. And we really respect and acknowledge what EPIC has done for many, many people over the years. So Marissa Ryan.
Hi everybody, thanks very much and thanks for having us here today on behalf of both the Youth Council and myself. Largely we usually have the Youth Council speak at most of our public events because we think it's most important for the voice of the child, and I'm usually kind of in the background crying or, you know, feeling really emotional because they're so inspiring. So what I'm here to talk to you about today is independent advocacy services for children and young people in care. EPIC is quite unique in that we are the only organisation. Oh no, I'm going to do a LEM now and not manage to click. Chair, how did you manage? I'm pointing. There we go. EPIC is quite unique in terms of the fact that we're the only national organisation in Ireland that provides independent advocacy services to children in care and young people up to the age of 26. Independent advocacy, I find, isn't generally very well understood across Europe, and people sometimes confuse the work of an independent advocate with a guardian ad litem, for example, or a social worker, and that's actually not what we are. So I'm going to give you a little bit of a talk about that and why we think that independent advocacy can be best practice in promoting the rights of and best interests of children. A quick note on EPIC, we do three things. We have three pillars to our work. The first is our independent national advocacy service, which is all Ireland. Only 11 people, so very overstretched, but we work very, very hard. And we meet children and young people on a one-to-one basis and support them through any aspect in relation to their care that they need help with. So that can be everything from a child in care review, a child protection case conference, up to and including court proceedings. The second aspect of our work is participation. So you saw our young people this morning. We have a participation programme that aims to bring care experienced children and young people together to share their experience and campaign for positive visibility of the care system and children in care, and also transform the care system and promote positive change. So our amazing young people do national advocacy campaigns. They run Care Day every year, and they are the ones who put the spotlight on what in the system needs to be reformed from their lived experience. The last part of what we do is research and policy. So we use the evidence base from our advocacy caseload to inform policymakers and officials on any gaps that we observe, both from the lived experience of the children and young people we work with, but also from what we see happening to them as we support them as advocates throughout their situation for the period of time they're in court with us. So, What is independent advocacy? Independent advocacy is really a process which allows a child or a young person to express their views and have them heard in any decisions in relation to their care. As I mentioned, that can be through child and care review, it can be through court proceedings, or it can be on something that's related, such as their care placement or their ability to go and see their mother and father or their siblings who might not be housed with them. We find that it empowers children and young people to ensure their rights are respected, it provides safeguarding, and it ensures that their views and wishes are heard when and where it matters. All of our work and the work of independent advocacy generally is grounded in Article 12 of the UN Convention on the Rights of the Child, which, as I'm sure you're all aware, governs the rights of the child to have a voice and to be heard and for their views to be considered. So how did independent advocacy come about in Ireland? Ireland was a little bit slower than some other Western European member states in embracing independent advocacy. In the UK, for example, there was advocacy services initiated for vulnerable children in 1987, and this was actually legislated for children in care specifically in 2002. Ireland learned a lot, obviously, from our child and protection and welfare system from the UK, so we started to observe that. Independent advocacy services for children in care in the UK were established on foot of a review in 1996 on the safety of children living away from home and some of the infamous inquiries into the abuse of children in state care in the UK, particularly in care homes in Wales, which was led by Sir Ronald Waterhouse at the time. So in Ireland, we started looking at independent advocacy for children in care in its current model around 2009 in response to the report of the Commission to Inquire into Child Abuse. And other speakers have spoken this morning, particularly Minister O'Gorman, about the fact that, to our shame in Ireland, we do have a long history of violating the rights of particularly children and women historically through being in care. Following the publication of the Ryan report, this is really awful. The Health Service Executive, as it was then, was tasked with implementing the details of the implementation plan which came out of the Ryan report, the Commission of Inquiry. There was 99 actions. The government very proudly actually committed to implementing all of them. And one of these was the recommendation around children in care having access to independent advocacy. At that time, it was cited that that should be through EPIC. We were formerly the Irish Association of Young People in Care. We're now the much more catchy EPIC. And that's how we started to work more closely with funding from the Department of Children and Youth Affairs, as it was then, and consequently with Tusla to implement our advocacy service. And why is it important? I think there's no point in me going back through what any of our young people spoke about this morning. I think everybody here is very well aware why it is so important that children have a voice and are heard, and that this has to go beyond a tokenistic aspect of what's in the best interest of the child, but really that efforts are made to find out what does the child actually want and establish where that sits within the proceedings in relation to their care. Children in care are expected to contend with a huge amount of very formal and bureaucratic processes that make massive decisions about their lives at a very young age, and often they do need support to be able to navigate that. Independent Advocacy Service also supports the statutory authorities in delivering their role as a corporate parent, because in general, our feedback from our advocacy service, from our children and young people, is that having an advocate has improved a child's experience while they're in care and can also improve their outcomes. So it is important for us to work in a multidisciplinary approach. To give you a quick flavour, and I'm nearly finished, of the types of situations or issues where children and young people require an independent advocate. I've just thrown up some data from our advocacy service 2020 to 2021. Just to be clear, these are individual cases. We find we work with about 1,000 children every year, and often they're opening multiple cases, so there's a difference in the numbers. But traditionally, care placement was always the first primary issue of children and young people who presented to our advocacy service. In the last 2 years, reflecting the kind of wider environment in Ireland, that's now changed, and our first main presenting issue is accommodation, up to, and as Jamie spoke eloquently to earlier, including homelessness for children and young people up to the age of 26 in our service. The second is care placement, aftercare planning and support, family contact, which is obviously seeing your family, and legal support. And Tusla also fund EPIC to deliver in partnership with Community and Law Mediation, an independent free legal aid clinic every year for children, or every month for children in care. Lastly, that's Alan in the middle, and other members of the Youth Council. In conclusion, we believe that child protection and welfare systems across Europe really need to look at the role of independent advocacy, look at how it's come about, look at why it works, and listen to the voices of children who've had an advocate and why they felt that was very important. I think, again, it was Jamie who spoke this morning about when things changed for him and his life improved, it was because he had an advocate on his side. The views and experiences and ability of children and young people to participate in decision-making about their lives are vital, and I think we all agree with this, to the development of child-friendly and child-centred policies. In Ireland, we have a holistic approach. We try to work very hard in a multidisciplinary way. And in terms of best practice, we do see that a child's best interests generally are served where an independent advocate works in close collaboration with a guardian ad litem, with the child's social work team, with their carers, and any other services that they may be in contact with. As we say in EPIC, and as the Youth Council proudly said at Care Day this year, it takes a village to raise a child. Thanks.
Well done, Marissa. Thanks very much. And now we have Diego Gallagher, who's also works with Tusla. He's the senior solicitor responsible for preparing all the documentation to go before the courts. Thanks very much.
Good afternoon, distinguished guests and colleagues. Something spoke to me earlier on is when Lauren talked about building the fundamentals. You can't build a house on sand. And I suppose in terms of, I'm a human rights lawyer myself, what are our values built on? What are the values of this state that's now over 100 years old? It's built on our constitution, Bunruch na Heran. Michael and colleagues earlier on spoke about various European United Nations principles and articles. And I suppose the one that we have in Ireland that we're proud of and that we've amended a number of occasions and amended the provisions in respect of children in it came in 2015. Article 42A.4.1. The best interests of the child is the paramount consideration. Article 42A.1.2, provision shall be made by law for securing, as far as practicable, that in all proceedings referred to in subsection 1 of this section, in respect of any child who is capable of forming his or her views, the views of the child shall be ascertained and given due weight, having regard to the age and maturity of the child. The Child Care Act 1991 has been amended on a number of occasions. You'll all be aware that is the bedrock act in terms of public law child protection in Ireland. And very happily, we have an amendment act which was signed into law just a couple of months ago, and I understand some of the provisions have been commenced as recently as last week. The old Child Care Act had a very short section on the welfare of the child, section 24, the welfare of the child as the paramount consideration, and insofar as practicable, to give due consideration, having regard to his or her age and understanding, to the wishes of the child. The new section 24A is a much bigger and much broader section, a far more helpful section in my opinion, where in any proceedings before a court under this Act, the child is capable of forming his or her own views, the court, insofar as practicable, shall, and it's a mandatory, it's not may, it shall determine the means by which to facilitate the expression by the child of his or her own views in the proceedings, and B, to give due weight to such views as the child wishes to express, having regard to the age and maturity of the child. And my colleagues referred to the best interest test, and I want to name what those new best interest factors are, because I think they're important. And my understanding is that the new Section 24 best interest provisions of the Child Care Act has been commenced, I think, as recently as last week. In any proceedings before a court under this Act, so the Child Care Act, the court shall regard the best interests of the child as the paramount consideration. The court shall have regard to all of the factors that it considers relevant to the child, including A, the child's age, maturity, and any special circumstances of the child. B, the benefit to the child of having a meaningful relationship with his or her parents and with any other relatives and persons who are involved in the child's upbringing. C, the views of the child where he or she is capable of forming and has chosen to express those views. D, the physical, psychological, and emotional needs of the child. E, the social, intellectual, and educational needs of the child. F, the religious, spiritual, cultural, and linguistic upbringing and needs of the child. And finally, any harm which the child has suffered or is at risk of suffering, including harm as a result of household violence. And as you're all aware, I suppose the voice of the child is heard in childcare proceedings, both via social workers, the parents, the child themselves, but via also guardians ad litem, hugely important independent advocates for children in the court process. In proceedings, so Section 26 of the old Act said that a judge may appoint a guardian ad litem. This has been amended by the new Child Care Amendment Act, the new Section 35A. In High Court special care proceedings, it's mandatory the High Court shall appoint a guardian ad litem. In the District Court, the Court shall direct that a guardian ad litem be appointed unless the Court is satisfied, having regard to all the circumstances that the Court considers relevant to the child, including the matters referred to in the best interest test, that the best interest of the child can be determined without such an appointment being made. So, for example, perhaps through the voice of a social worker or some alternative means of doing that. And B, in respect of a child who is capable of forming his or her own views, the court has determined other means by which to facilitate the expression by the child of those views. So I want to congratulate the Department and the Minister for bringing in what, in my view, is very progressive legislation. In my view, it places children in a stronger position in two important aspects. Firstly, it outlines clearly what a court should consider in terms of best interest. And secondly, it gives explicit provision for the views of the child to be heard in court. And there's, I suppose, a presumption that guardians ad litem should be appointed. The state body, as my colleague Ger spoke earlier on, charged with the protection of children in Ireland is Tusla, the Child and Family Agency. And I just want to refer to two important pieces of legislation. One is the Child and Family Agency Act itself, the grounding piece of legislation, the 2013 Act. Section 9 says that the Child and Family Agency shall regard the best interests of the child as the paramount consideration. It is infused in the values of the Child and Family Agency. It also says that the agency shall, when performing all of its function, be it under the Child Care Act, under the Education Welfare Acts or the Adoption Acts, shall ensure that the views of that individual child, where that child is capable of forming and expressing his or her own views, shall be ascertained and given due weight, having regard to the age and maturity of the child. It is mandatory and infused in the values of the Child and Family Agency. I'll also mention one other act, the Irish Human Rights and Equality Act. Section 42 requires all public bodies in the performance of their functions to protect the human rights of its members and the persons to whom it provides services. And I say that the views of the child, the best interests of the child, are intrinsic and essential in the delivery of the protection of human rights by Tusla in accordance with that act. Very briefly, and I know President Kelly will speak to this later on, childcare proceedings are held in the District Court in Ireland with appeal to the Circuit Court. Special care proceedings are heard in the High Court. There are specialist District Court childcare courts in Dublin, the formerly known as the Bridewell, now the Chancery Courts. However, there is no rollout of specialist courts throughout the country, and sometimes we I suppose, have the appalling vista of childcare cases being interspersed with on a criminal law day and a family law day through no fault of the court service at all. It is a resource issue, and we look forward to the Family Law Bill, the Family Law Act that will come forward to a specialist family law court. So in practice, the voice of the child is brought to a court by a combination of, I suppose, Tusla social workers in accordance with all the work that Ger outlined earlier on, the house of worries, the house of happiness, etc. And through parents. Parents, of course, are important, very, very important to the process. Guardians ad litem, which in my view should be appointed in all cases as essential independent advocates. Children can have solicitors themselves. Section 25 of the Act permits the judge to appoint a solicitor for a child. I've seen it done, particularly when children perhaps are 14, 15, 16. I suppose the obligation on the guardian ad litem and the Tusla is to inform children of their rights. You have a right to have a solicitor if you want this. Guardians ad litem generally instruct legal teams, and the lawyers are permitted to engage in direct examination and cross-examination. In my view, it is essential that children have equality of arms, that their lawyers have the right and the opportunity to undertake direct and cross-examination to properly advance the views of the child before the court. Very briefly, because I know I'm finishing up, what is the voice of the child in childcare proceedings? And in my opinion, it is broader than simply addressing the question, where am I going to live? Who is going to look after me? That voice is also saying, I want to get the therapy or education that I deserve. I want to learn about my cultural heritage. I want to learn about my identity. Fortunately, the practice of the District Court in Ireland requires comprehensive care plans and social work reports. The case law in Ireland, led by the Eastern Health Board and MacDonald, is clear that the 1991 Act was intended to give the overall control of children to the care of the District Court. And I'm pleased and proud to say that the judges of the District Court take a profound interest in all aspects of the welfare of children. This means that the voice of the child needs to be heard on all aspects of their welfare, and I suppose hence my earlier reference to those 6 or 7 factors of the best interest test that are gone through in court in a sustained and dedicated and careful way by judges there. So in summary, positives: very good, skilled cohort of expert social workers, guardians ad litem, lawyers, a court service. There is work to do, there's no doubt about it. My colleagues have referred to it earlier on. We need a dedicated family law court system. We need dedicated resources. We need more, for example, advocates for parents who may have a disability. We need guardians ad litem for children. And I suppose one issue, what is missing, what I wanted to say, the advocacy earlier on from my 4 friends here was just tremendous. I think that they would make wonderful human rights lawyers if they were ever interested. And I really am humbled to hear it. So on that note, thank you.
Many thanks, Diego. Now we're going to be joined by His Honour Judge Paul Kelly, President of the District Court, who I suppose has some of the most difficult decisions to make on a daily or weekly basis in relation to these cases, and I don't envy you your task.
Good afternoon, everybody, and could I first of all thank the Department of Children for the invitation to join you here this evening. I suppose in the interest of transparency, I should say that as a judge, I was I'm a judge now for almost 12 years. The first 10 years I spent as the judge in County Donegal, and in that time I dealt with hundreds of childcare cases. And I suppose in that context I might be seen by some people as the bad guy, because I have personally made orders taking hundreds of children into care over those years. And I'm probably going to be regarded as even more of an ogre now when I tell you that since, for the last year and a half, I have sat as the presiding judge in the Children's Court here in Dublin, which is the court that deals with juvenile crime. And in that context, I've unfortunately had to send some children, not too many, into detention. So I'm sort of the bad guy here, and I'm very conscious of that. I'm also conscious of the fact that I'm certainly not an expert in any particular field, and I'm conscious that I'm speaking to an audience comprised largely of people with expertise. It may shock some of you to know that when you're made a judge, you don't suddenly become endowed with knowledge, wisdom and expertise in all the areas that you're going to have to deal with as a judge. Certainly I had very limited experience of childcare, so it was really learning by doing, learning on the job. And the training that judges get generally, and particularly in relation to childcare, at that stage was somewhat ad hoc. It has improved quite a bit since then. And the new Judicial Council Act came into force in 2019, set up a judicial training, a judicial studies committee, which now, if you like, has formalised a training regime. I'll come back to that later on in my presentation. Just a quotation from Baroness Hale, who, prior to being renowned for the lady who wore the spider brooch while giving judgment live on TV, had previously been president of the Family Law Division of the High Court in the UK and is regarded internationally as an authority on childcare. And she made the very obvious comment in a case, it is the child more than anyone else who will have to live with what the court decides. And I think that's really what's at the root of everything here today. As a judge, sorry, let's get that out of the way. And I'm going to put that out of the way as well. We've heard a lot of people talk about the legal framework, and I'm not going to go into that. I'm just going to give you just a couple of, if you like, thoughts about what we as judges need to know and need to hear when we're deciding childcare cases. Can I start by saying that no judge takes a decision to take any child into care lightly. It's about the last thing that you want to do. And I'm pleased and proud to say that in my experience in the district court, it's something that the judges take extremely seriously. It causes a lot of anxiety among judges. I've certainly agonised over many decisions in childcare cases. A lot of them, the decision is pretty obvious at the beginning, but it's the cases where it's marginal. They're the ones that keep you awake at night. They're the ones that provide you with a huge amount of difficulty. So in making those decisions, we will hear evidence from the parties themselves. We will hear submissions from the lawyers, and some of the previous speakers have adverted to that. We'll hear evidence from experts. We'll have attachment experts. We'll have psychologists. We'll have people who have observed access. We may hear a variety of other different types of experts and therapists. We'll hear social workers. And just, if I can say, and I'm conscious that Ger is here and other people from Tusla, social workers, in my view, are the saints of the childcare system. They're very often regarded by many families and people as even worse than the judges. But in fact, they do a job that I certainly wouldn't do for any money. And also guardians ad litem. The hearing of the voice of the children has changed in practice since the coming into operation of the 2015 Act. And I think that has had one negative outcome, in my personal opinion, that it has made judges less likely to hear directly from children. There's now too much reliance on the expert reports under Section 32 and the Section 20s, and they have brought their own problems. I'm very conscious that my time has run out. I want to come back to that because I think judges should, wherever possible, listen to children personally. And I know when I started up in Donegal and did my first few childcare and private family law cases, I instinctively felt I should listen to the children, and I did, even though there was no framework for it at that stage. And I'm very grateful for colleagues at all court levels who gave guidance as to how we should do that. But I'm firmly of the view that where possible, we as judges should hear from children directly, as well as the experts. Just very briefly, I want to talk about the time, because it's been referred to, and it's the one big problem that I see in childcare. It takes too long for a childcare case to be resolved in Ireland, and that leaves children in the limbo of interim care orders or voluntary care arrangements for sometimes several years, and that has enormous impacts on the child's life. 2, 3, 4 years in interim care, not knowing whether they're going to stay in the foster home, not knowing whether they're going to be moved somewhere else, not knowing whether the foster parents that they're staying with are going to be their long-term foster carers if they're taken into care, not knowing if they're going back to their family. It's an enormous problem, and it has disproportionate impacts on the child's development. Why does it take so long? Number of reasons. Not enough social workers, so the social workers are under serious pressure. Ger has referred to the difficulty of getting social workers, and I can see why when I watch what social workers have to do. That makes assessments take longer. Various types of experts are in short supply, particularly in rural Ireland. There are parts of the country where it's very difficult to get an expert in certain areas. Sometimes the fault is with the family themselves, they're not cooperating. The one that Carol mentioned, where there's a crossover between a Garda inquiry and a childcare case, is an enormous problem. It doesn't affect every case, but when it does affect a case, it's a huge issue. You have two consequences of it. First of all, it derails the childcare proceedings themselves, because they're effectively put on hold while the Garda investigation is completed, which means that the interim care orders are just rolling along month by month on all the problems that they bring up every month, every few months, rows over access, rows over various things that affect the children. But secondly, it leads to the duplication that we should avoid. It leads to children being repeatedly interviewed about the same thing by the experts in their own childcare case, but also by the Gardaí. And the problem that the Gardaí have in these cases is there are very, very few sufficiently trained child expert interviewers. So there's a waiting list for children to be interviewed in cases where there might be criminal proceedings going on. And secondly, that raises a conflict, in my view, which I tried to explore by sending a case to the High Court to work out what is the constitutional balance between the rights of the state and society to prosecute serious crime and the rights of children and their families involved in care proceedings. The Gardaí won't release any documents or interview notes for pretty obvious reasons during the currency of their investigation, and that can hold up the progress of the childcare case, because the respondents very often need to see what the children have said to the Gardaí, which obviously the Gardaí don't want to release. That's a huge problem. It hasn't been satisfactorily resolved by the superior courts. There is a case stated which I sent up to the High Court, which, for a variety of technical reasons, wasn't heard by the High Court because the Garda investigation had concluded by the time it got to the High Court. The question of whether it should be decided is now gone to the Court of Appeal for a decision, and I'm hoping that that will help us resolve the contract. I'm going to finish now. I know I'm way over time. What did the District Court need in order to do its job better? It's the R word. We need resources in social work. We need more social workers. We need more of the various experts and therapists. We need more judges ourselves. We are flat out doing childcare, and many of the delays are simply because we don't have judges. I don't, as President, have judges to send around the country to hear childcare cases that can take a week, 2 weeks, 3 weeks, 4 or 5, even 6 weeks to hear. There's one particular case that it took 120 days at hearing, spread over 3 years, and you can imagine the impact on that family. So the new family law bill, which we're looking forward to, will hopefully address some of those issues. There's also non-court resources in terms of staff for the court service and the various support services that other people have referred to around the whole question of, or around the families themselves and the children in care. And then training for judges. That's really, really important. We need training to hear the voice of the child, but we also ultimately have to make the decision. Sometimes it won't be the decision that the child has said to us they want. They come to us, they speak to us, they give us their view. We sometimes have to make a decision that we feel is in the best interest of the child. It may not coincide with the child's child's view, but that's our job, unfortunately. Can I just thank Adam, Arsene, Lauren and Jamie for their absolutely wonderful presentation this morning. It was humbling to hear it, because while I've heard children through the care system, I've very rarely heard children who've come out of the care system, except for one very sad feature of my life at the moment. Many of the children I deal with in the Children's Court are children in care. There is a disproportionately high number of children in care who come before the Children's Court, and I think that is a failure of society. It's a failure of what all of us are trying to do for children. So with those few words, I thank you for your attention.
Many thanks, Judge. Thank you very much. And thank you for those rich presentations. And I think we could have 5 days of discussion and presentations. But we have 15 minutes for questions and answers. And what I would appreciate if would people stand up and identify themselves. We don't have a mic, so if you are as articulate and as forthright and as passionate as possible in relation to your question, there's a good chance that the panel will hear you and will respond. There's one mic there. So are there any questions anybody would like to ask? There's a gentleman at the back there.
Hello there. Thank you, panellists. Brendan Day is my name. I'm a barrister. And the question for all of you is, the fact a child comes maybe to give their view to an expert, and of course they'll be influenced by what they had for breakfast, what they're wearing. But I suppose the question is, at what point does their context give rise to an undue influence on, let's say, what they say to an expert? And how do we, as, let's say, Europe, deal with that nuance going forwards? Because it could take a week to just get to the bottom of that question.
I think if you just repeat that question one more time, the core of the question.
When a child is stating their view, when does an influence, in terms of where they're coming from, their context, become an undue influence, and then therefore, I suppose, beg the question, can we go behind what they are saying?
Judge Kelly?
Can I just maybe very briefly touch on that, because one of the things that always terrified me when I'm hearing, and still does when I'm listening to children in that context, is, are they being coached? Have they been unduly influenced? And more importantly, how can I tell? I don't have the specialist training to work these things out. You very rarely have enough time to go into it in any depth, and you're relying on gut instinct. But I've absolutely no doubt that context is hugely important. Clearly, if a child, for example, has been living with one parent to the exclusion of the other, they may well have been given a very negative view of the other parent, and that's something that we have to try and factor into our decisions on a daily basis.
I wonder, Marissa, would you have any insight into it as well? And I'll come to Maria.
Thanks. I think the point from our perspective as independent advocates is we need time to establish the relationship with the child or young person. And during that period, the whole basis of our engagement is we work for the child. So as soon as we get in contact with them, they self-refer. So we work on the basis, largely the majority of children and young people in EPIC self-refer. We are able to work with them to ensure, firstly, do they know what's actually happening? Because even, as you heard this morning, 2 of our young people who spoke still don't actually know why they were taken into care. So it's our job as advocates to make sure that the child or young person understands the circumstances around them, and then they're supported by the advocate who has generally a longer relationship with them to communicate, establish a view of what they want, and engage with the professionals around them. And as Judge Kelly said, what's in the child's best interest isn't always going to be what the child themselves wants. So from an advocacy perspective, a lot of our role is also to temper the expectations of the child and work with them to ensure that they understand what is actually best interest, even if it's not what they necessarily want. So for us, it's about providing that wraparound service, not duplicating the work of the guardian ad litem or the social worker or their barrister, but because we have more time with them and we have a longer relationship, ensuring that both before, during and afterwards, that they understand, have their views heard, and in a way it then becomes much clearer to their advocate as well whether there is undue influence going on.
Thanks, Marissa. I think Maria wanted to come in.
Just briefly. Just for people who aren't familiar, it is very rare that a child themselves appears, attends in courts and participates in the proceedings in Ireland. So it is the majority, if there is any views of the child, it is mediated either through the social worker or through the guardian ad litem. And the guardian ad litem, as Diego mentioned, is not a requirement in all cases. So there's a very mixed bag as to what's happening in court. And I think what we have seen some good examples of is where, because there isn't, when you're listening to the proceedings, well, there isn't necessarily a standard procedure. There may be within the documents, but we haven't got sight of them. And as I understand, I don't know if there is a standard procedure across the country where there is a clear place where the views of the child are clearly written down and clearly explained how they got, what were the circumstances. Because obviously child protection, child coming into care may happen in an emergency. There may be no time to ask for the child's views. The child may be very young. It may not be possible to ascertain the views. That's just the complexity of child protection. But if you are in a calmer court environment where you're looking at a final decision of taking a child into care, there needs to be very clearly defined where are the views of the child, what are their wishes, how are they ascertained. And just a couple of things then, just to mention that another element of all of this is not just that the child has their say on what should or shouldn't happen, and as Marissa's just said, and Judge Kelly, they can be balanced, they can be weighted. Is that actually in the best interest of the child? But also, children just need to be given a sense of what's happening. So Arson didn't get a chance earlier in the earlier session to come back to the point of meeting the judge. So I asked him, with permission, what was that experience of meeting the judge? And he described being brought into not the active court, not during the proceedings, but before the proceedings, to meet directly with the judge. And that experience of just putting a face to the person who's going to make this decision. And I think that's really important. Seeing the courtroom, meeting the judge, and Judge Kelly said that without guidance and without necessarily the time being built into the system, he is doing that. But I'm just, with respect, we have a very mixed bag of courts in Ireland, and good practice in many of them, and we would say not such great practice in others. They're too busy, they don't have the training, they don't have the resources, so we need to improve in that space. And then just finally, there's another thing that's happening, and it's really exciting that's happening internationally in terms of justice for children. So if this case is about children, then let's produce a decision that is written in child-friendly language that they can read. And there's some really good practice happening internationally. I think the UK has got most attention. We've also had good practice here in Ireland where you have the official legal judgment, then you will have a short judgment just explaining, I listened to you, I heard these views, this is my decision. And I think, again, it's about giving the judges the time to be able to do that, because I think that's really valuable.
Thanks very much, Marissa. I think Ger wants to come in very briefly, Ger.
Yeah, just two brief comments. I think, firstly, a child at 8 may not make the right decision, but it might be the decision that's right for them at that time. And why would that be any less valuable than what somebody else thinks at a later time? Or even what that child thinks at a later time? Why would that be any less valuable? The second thing is, we're introducing a model of care here for children who've been sexually abused called Barnahus, based on an Icelandic model. And key in that is a multidisciplinary assessment and one interview, so that the child has their voice heard at once, it's videoed, and then used several times. And children are saying to us again and again, why do you keep coming back with the same questions? We've answered this question already. We asked the same question to 10 different groups. Why would we do that? Children are able to express their view, and we should reuse that, but do it in a way, like Marissa was saying, where there's a relationship built and it's meaningful, but it has to be meaningful.
Thanks very much, folks. I think we've time for one or two more questions. There's a lady there. Thank you.
Hello everybody, my name is Katrina Nickfurish. I'm a kinship carer. I am the founder of Kinship Care Ireland, and I'd like to talk especially to Alan, who's in the care of his grandparents, and how valuable and how important that is. So when hearing the voice of the child, when it comes to placement, asking the child where they would like to live, where they would like to go to school, where they would like to be in their community. And unfortunately, the bulk of the children in kinship care in Ireland are in informal space. They're outside of the care system. And the question I'd love to ask is, within the review of the Child Care Act, within the judiciary, within the courts, could you please look at the orders that would allow for parents or carers to work together to place children with relatives for the best outcomes for the children. I care for my 4 nieces following the death of their parents. They were able to stay with us as a family. I share my birthday with my sister who died. I'm a triplet. You know, they stay in the communities. So the benefits for the children for staying with their relatives, to staying in their communities, to be supported to do that is immense. I'm 10 years at kinship care. My young nieces, now young adults, are flourishing. And they asked me in the beginning, Katrina, where would we be if we weren't with you? I said, potentially you'd be with strangers, split up, because there was 4, and in other parts of the country. And I know in the UK, under the review of the children's services, that they looked at the whole area of special guardianship. So I'm just wondering, could we please look at the whole area of keeping children out of the care system, but with the security and safety of legal status with guardianship to protect the children?
Thanks very much, Katrina. I don't know if anyone on the panel is in a position, because I think it's more the department to decide that.
Well, just very briefly on that. In my experience, when a childcare case comes to the district court, the first thing Tusla will have done is that they will have looked at the family to see is a relative or a kinship care arrangement possible, and that clearly is a preferred option. And for us as judges, it's an easier option if there are willing relatives who are in a position to care. But all too often, the reason stuff comes to court is because there isn't. And that, if you like, widens out. The other major shortage I should have referred to when I was saying what's needed here is actual foster carers are incredibly difficult to find. And that's why kids sometimes end up in another part of the county, another part of the country, having to change schools. It's the last thing you want to do, but sometimes it's the least worst option.
Ger, briefly.
Yes, so there is, you think about kinship care, relative care, we need to define that much better in the country, and I'd agree with what the questioner just sort of proposed there, that special guardianship would be considered stronger. I think that would be a real benefit. It would also fit very much with the model of care we're trying to get, where it's more working with the network around a child and around a family. So even if it's not family, if it's a relative or a friend, that somebody else in that community can step in to do that. But we need to provide the framework that supports that keeps that safe. So even if it's not a direct relative, is it somebody who's connected to it? And then how do you balance the rights of the family in that situation and the rights of the child to make that work? So we need a whole framework around that. I think we're a while away from that, but that would certainly help us.
I think as well the opportunity for the review of the Child Care Act provides a very good platform for that. So the time is right for us to be considering that, and the time has been right for quite a while. One last question, I think one brief question, one brief response, if we have any other final question. The lady in the front here.
Hello, my name is Kater, and I am a French family lawyer. You said that judges are always the bad guys, but lawyers are quite have a good reputation on that aspect as well. So, and I have the feeling we are talking a lot about proceedings, but not about lawyers. And there are a lot of lawyers who are ready to specialize. I know that in France there is no specialization of lawyers for children. We have now training to be auditeur d'enfants, like really ready to listen to the children and to represent them. And I have the feeling that sometimes judges would receive a lot of helps having in front of them a lawyer who is in touch with all the stakeholders for the children. And yes, I was surprised that there is no lawyer in the panel. Once again, maybe it's because we are the troublemakers, but
and I think
there's a lot of, yes, you said that they are allowed to be solicitors. Yes, you said that, of course, but yeah, I think it's something which should be maybe automatic. One child, one lawyer could help.
Maybe it's a system issue as well, I think, in relation to where our lawyers start and end and guardians ad litem start and end here. Would you like to answer that, Diego?
Just briefly, I mean, I entirely agree. All solicitors working with children, all barristers working with children should have trauma-informed training, should have extra training. They should be vetted as well. everyone who works with children, including judges as well, I should say, I'm sure you'd agree with me, should have that training and expertise and support, because it's about helping us. I wouldn't like to be in President Kelly's shoes, but we need all the support we can get. Yes.
Thanks very much. So I think, unfortunately, we're nearly at the end of the time. I'm getting frantic signals to say that we're at the end of our time. We have to have a quick lunch before we head into the afternoon session, and I think that's going to be very informative as well. But just very, very briefly, just to do a whistle-stop tour. The position in Ireland in relation to the rights of the child is radically different to what it was 10 years ago, just 10 years ago. In 2015, we had the constitutional amendment affirming the children's natural and imprescriptible rights. So we have the right for children for their best interests to be of paramount importance and paramount consideration. We have had the Childcare Amendment Act 2022 and the presumption in favour of a guardian ad litem, and including provisions for the regulation of the guardian ad litem system. That's a significant leap forward. Family Courts Bill, significant leap forward in thinking. Review of the Childcare Act, the strengthening of Tusla. So we've come a long way, but as has been pointed out earlier on, we can't be complacent, because who knows when we're looking back at a lens in 10, 20, 15 years' time, how awful we'll think that we're behaving now as opposed to being complacent about the way we're behaving now. Not that I'm suggesting we are, I'm just urging that we move forward constantly and review constantly. What do we need still? Ireland has come a long way, and what do we need still? We need to reduce delays. We need dedicated childcare days in court. We need the resourcing of state agencies which assist the court with reports and expert views. We need improved physical facilities so people aren't terrified when they go into a courtroom or an alien courtroom setting. We need a movement away from the adversarial approach towards an inquiry approach in childcare proceedings. And we need specialist training for judges and legal practitioners. Again, that has come a long way, but more could be done. And also we need, as somebody mentioned earlier on, support for structurally vulnerable groups who are disproportionately present in childcare proceedings. So we are constantly striving for the best for our children. The Council of Europe provides an important forum to share ideas, to learn and to strive for the best. We need events such as this to facilitate that learning. The best interest of the child is the best interest of a just, fair and equitable society. Gur míle maith.